You may begin.
Hello, my name is Susan Farah, and I want to welcome you today to the Special Transportation 101 video training. I am an exceptional children consultant with the Kentucky Department of Education, and I have with me today Jennifer Riley, who is an early childhood consultant with the School Readiness Branch. Our contact information titles are below, and we are happy you're here. Thank you for joining us. The one thing that I wanted to bring to your attention is we do have written guidance concerning special transportation for students with disabilities. The guidance for special transportation in Kentucky guidance document, it covers a variety of topics relating to transporting students with special needs or with disabilities. The webpage link is below, and feel free to access that if you need to look up some information. Today's training agenda, the first topic we're going to go over are some relevant laws that pertain to students with disabilities. We're going to talk a little bit about Section 504, some about the Individuals with Disabilities Education Act, and the Family Education Rights and Privacy Act, or what we call FERPA. The second topic that this training will cover are some basic IDEA rules, basic special education rules. We'll go over eligibility, least restrictive environment, routing and scheduling, extracurricular activities, discipline and suspension as it pertains to transporting students on the school bus or other form of transportation. The third topic, which will be covered by Jennifer Riley, is going to be preschool and early childhood transportation and transporting students that are very young from that perspective. And then the last section will be some resources and contacts, which we hope will be very helpful to you as questions arise or as issues come up. The first law we're going to go over is Section 504 of the Rehabilitation Act of 1973. The second law, and the one you all may be most familiar with for students who have individual education programs or IEPs, is the Individuals with Disabilities Act of 2004, what we call the IDEA. The third law governs the confidentiality and privacy of personally identifiable information in student educational records. The law is called the Family Education Rights and Privacy Act, or more commonly known as FERPA. And the last law that we will go into just in a cursory, brief manner is the Americans with Disabilities Act, which was signed most recently in 2008, but it was first passed in 1990, and that's going to be most commonly associated with questions that address service animals, although it's not restricted to that. Section 504 was originally passed as part of the Rehabilitation Act of 1973, so it's been around, it's been close to 50 years. To be eligible under Section 504, a student must be determined to have a physical or mental impairment that substantially limits one or more major life activities, or, and these are or here, so only one of these tests have to be met, have a record of such an impairment, or be regarded as having such an impairment. An example of the third one would be students who maybe HIV positive, but they are not showing any signs currently that the disease is adversely affecting them or has turned into AIDS, but that is an example. And the reason for that is because of the stigma that was associated with HIV and AIDS at the time the law was passed, because AIDS was very, very shortly to come in the late 80s. They added that in as, a criteria under which a child could be eligible. When a child is eligible, they will receive a plan where they receive reasonable accommodations. Now, Section 504 does not necessarily require that it be a written plan or put into writing, but it would be advisable for districts to consider doing that for their protection, to put their agreed upon plan of accommodation and service into writing once the team of professionals meets with the parent to decide what the child needs under Section 504. Section 504 is overseen by the United States Office for Civil Rights, U.S. Department of Education's Office for Civil Rights. Kentucky is located with a few other states in the Philadelphia region, so we're overseen by the Philadelphia Regional Office. Section 504 does include special transportation as a related service for a student with meets eligibility as a child with a disability under 504. And so a student that has a 504 plan or who is eligible under 504 may qualify as a related service under 504 if it is needed to even the playing field. The kind of easiest way to think of Section 504 is to think of it as an anti-discrimination law, and one that applies to all entities that receive federal funds, which would be public schools, the overwhelming majority. And so if the child needs a related service such as special transportation to even that playing field and to allow the child to equally participate with their peers, then that would need to be provided. The Office for Civil Rights will look into allegations that are made involving lack of training for bus drivers or aides concerning transporting students with disabilities, especially connected with harassment or discrimination. This includes specifically targeted training that is necessary to address a student's distinctive medical needs during transport. So if a child needs a special medical intervention that, such as a child with diabetes who might need a glucose injection or an insulin injection, the district would need to ensure that the child's distinctive medical needs are met during transport, and make sure that the appropriate staff is trained in how to do that adequately and safely. There is a case from OCR that it investigated, and if the case was from New York, and it found that a New York school district violated Section 504 when the district failed to train a bus driver on the student's diabetes plan and how the student's diabetes would need to be managed at school and on the school bus. The second law that we'd like to cover is the Individuals with Disabilities Education Act. And the relevant regulations for Kentucky and for federal are listed underneath each bullet point. Every eligible child who has a disability and requires special education services will have a written plan called an IEP. There does have to be an adverse effect upon the student's learning. And, oh, I'm sorry, I hit the forward button too soon. Every child who has a disability will have the special services, including related services, detailed in their IEP through the admissions and release committee process, which I'll get into in a bit. An IEP shall include a statement of specially designed instruction and highlighted in blue font. It also includes related services and supplementary aids and services that the child will receive in order to receive a free, appropriate public education. And just a brief description of what FAPE is, free, appropriate public education. Free means that the services and supports will be provided at no cost to the parent. Appropriate under the IDEA means that it meets the child's unique, distinctive needs. Public, of course, means as opposed to private, and education means that the child learns, that the child makes progress on their IEP goals and in the general content curriculum in light of their unique circumstances. That there's a new Supreme Court case that really goes into depth. It's called Andrew F. about the definition of a free, appropriate public education. The next law is FERPA, and it concerns the confidentiality and privacy of student educational records, especially the personally identifiable information contained within them. And what FERPA governs is the protection, maintenance, and destruction of such personally identifiable information and the school district staff's responsibility in those areas and what they need to do. Also, Kentucky Special Education Law 707 KAR 1:360, Section 8 requires that all staff in the district who are collecting or using personally identifiable information contained in student records, including transportation personnel, must receive training or instruction on the requirements under FERPA. So it's important that the special transportation director and the special education director work together to make sure that anyone who's transporting children and who will be having access to personally identifiable information will need training on FERPA requirements. Related services, as you will see under 707 KAR 1:002, Section 1, Paragraph 51A, it provides a definition of what a related service is under the IDEA. Related services, first one off the bat, is transportation. It goes on to mention other services such as counseling, psychological services, speech language pathology or therapy, therapeutic recreation, several different examples of what a related service is. And special transportation is the first one mentioned. So I think that that's important for us to be aware of from the perspective of our General Assembly legislature. Special transportation does not just include transportation to and from the school building for a student. It can mean other things as well. It includes transportation when needed for travel in and around school buildings. It requires special transportation when the student requires it if they're participating in community-based instruction. For example, a lot of students when they reach the age where they're considering post-secondary transition will go out in the community and participate in different vocational activities such as job shadowing or interning. And if the student needs transportation, uh, then that would need to be provided. Or if it's something just like going to practice functional skills such as ordering at a restaurant or doing shopping at the grocery store. A lot of districts focus on those skills, and the district would need to make arrangements for community-based instruction when students need it. Field trips and non-academic activities. It also includes specialized equipment, which is defined as special or adapted buses, lifts, and ramps when required to provide special transportation for a child with a disability. So a child, might need a Hoyer lift, or there might need to be a special ramp depending upon the individual circumstances of the student. And then also for participation in school and district offered activities. I think about your evening band concerts that, if a child with a disability participates in band and they're going to need special transportation to get to that evening holiday concert, then that is something that the district is going to need to plan for and decide as a group in the student's IEP, and then it would need to be fulfilled. When looking at whether or not a student needs special transportation, the ARC team, which again stands for Admissions and Release Committee, needs to think of several things when they're determining whether the student should be eligible for special transportation. And the overarching guiding question is, does the student require transportation to benefit from their educational program? Different factors to consider would include a student's mobility. But it's important to note that an ambulatory impairment or not necessarily being able to walk well or walk at all, that's not necessarily going to mean that the child automatically qualifies. It is a factor that they need to consider along with other factors for special transportation as a related service. The student's behavior, the student's communication skills, the student's physical needs, the student's age. For example, the need for special transportation may very well be different for a very young student with a disability as opposed to an older student with a disability. But again, it's a team decision that's made by the ARC. The student's ability to follow directions. Another factor to consider is the distance the student will need to travel. Are they able to make it to the bus stop? What would that mean for the student? And then the nature of the area. And we'll get to one case that kind of talks about traffic and how that is a factor that impacted the decision for the student in regard to the transportation services they were receiving. Let's see here. The first case that I really wanted to go into depth about is a case from the Sixth Circuit. Kentucky is in the Sixth Circuit, and so it is binding on us. The Sixth Circuit U.S. Court of Appeals. It's an older case from 1989, and some of the language isn't what we would consider to be disability friendly, but I've quoted the law here. But it's called McNair versus Oak Hills. And it is binding on Kentucky. And I'm going to read through the facts of the case to you. And then the Sixth Circuit ultimately came up with a test for determining whether a student is eligible to receive special transportation. This case involved a primary grade student who was enrolled in a private school by her parents unilaterally. The parents paid the student's tuition to attend the private school and transported the student to and from the private school. The student had a hearing impairment, that was her disability, and it did qualify her for a free appropriate public education under the IDEA. The school district, Oak Hills, was willing to provide this young lady with an appropriate education at the local public elementary school. The distance from the student's home to the private school was more than 2 miles, and Oak Hills as a district did provide free transportation to elementary and primary grade students who were disabled and non-disabled residing in the Oak Hills School District and attending non-public schools that are more than 2 miles from the students' residences. The parties, the parents and the school district both agreed and stipulated that the student's disability did not keep her from or preclude her from using regular transportation, or what the court referred to as non-handicapped transportation services. But the parents wanted special transportation. So the parents asked the district to provide the student with special transportation to and from the private school, and the Oak Hills School District refused. It went up a chain from the disagreement to, it went to a due process hearing. Then it went up to the district court magistrate. And then the district court adopted the magistrate's recommendation. And the district court said, under the IDEA, related services are those services provided through state-financed and controlled special education programs, and the private school did not qualify as special education. And so the parents appealed to the Sixth Circuit. So we have the district court saying, you know, it's the private school was, you know, not responsible for providing special education, and that was the reason. The Sixth Circuit took this up, and they decided that there are 4 factors to consider when the student should receive special transportation. And this is an and, 1, 2, 3, and 4. So all requirements need to be in place. These are elements that need to be in place. The student must meet the definition, as the court said, of handicapped. The word that's used in the regulation now is child with a disability or student with a disability. That transportation is a related service. That is the easiest one under our current regulation, because special transportation is a related service under the IDEA. And the third one is the one I want to bring your attention to the most, and it says that special transportation as a related service, the student should only be eligible in order to meet the unique needs, the distinct needs of the student caused by the disability. There has to be a connection to the disability. And then the fourth one, the school district must be responsible under the IDEA and its regulations for providing the related services under the particular circumstances at hand. And it's still specified as a related service, and the decisions made by the ARC, or Admissions and Release Committee. One more slide about McNair. The Sixth Circuit held, what they decided was that the third part of their unique needs test was not met because the student's unique needs caused by her hearing loss, her disability, were not such that she needed special transportation as a related service. Regular transportation would have worked just fine for her, according to the Sixth Circuit Court of Appeals. As a result, the Oak Hill School District was not required to transport the student to and from the private school by special transportation. One concept that is very, very important under the IDEA is the concept of least restrictive environment. And I'd like for you to envision a ladder that is open that you're getting ready to climb. And the district has to offer a continuum of placements. And if you look at the lower rung of the ladder, we're always going to start with considering regular classroom or the regular school bus, in this case first. Can the child participate in regular transportation with some supports, some accommodations, some modifications? Then you move up, and it might be something a more restrictive placement or means of transportation, such as maybe a resource room, which would be in the school building, or maybe a special bus. And as you climb up, you get fewer and fewer students, and it can be, amount to possibly even a contracted vehicle or a board-owned vehicle, depending upon the needs of the child. And so that, maybe just transporting one or two students. That way, depending upon the child's needs, thinking about buses being very bumpy and sometimes hot without air conditioning, and sometimes smelly. Students who have disabilities which impact them in their sensory arena may not be able to tolerate not only a regular bus, but also a smaller special bus, which is what you usually think of. But the U.S. Department of Education, in its commentary, stated that it is assumed most students with disabilities will receive the same transportation provided to non-disabled students, consistent with the LRE requirements, unless the IEP team, or what we call in Kentucky the ARC, determines that the student needs something else. And so if you look at it, as I say, like a ladder, most of the students with IEPs are going to be able to be on a regular bus and use regular transportation just fine. They don't need it necessarily as a related service. Or if they do, they can ride, a regular school bus with their non-disabled peers with some supports and modifications. And then as you move up, fewer and fewer students, as you move up more restrictive modes of transportation, you're going to have fewer and fewer students that are going to need that. Let's see here. Other factors to consider when determining a student's least restrictive environment, just some questions that the IEP team or ARC, with the participation of district or school transportation staff, they should ask themselves, can regular transportation be effectively and appropriately implemented with supplemental aids and services? Will the student be able to be transported safely and effectively if we, with their non-disabled peers, if we just provide some additional assistance? The second bullet to consider, do the advantages of the student riding on a regular bus or in regular transportation outweigh the benefits of a more restrictive transportation arrangement? And then the third bullet, are there any adverse effects, negative effects that the student or other students will encounter on the vehicle if the student does ride in regular transportation. All three of those are things to consider. The one thing I want to stress is least restrictive environment. It may be a lot of things, but it is not placing each and every student on with a disability who needs special transportation on a special school bus. It is not making a blanket decision to place each child with a disability on a small special bus. Many students with disabilities can effectively access special transportation through accommodations and supports that are provided to them on the regular school bus. And the ARC team, with the transportation staff involved in the decision making, they should always consider first whether the student's needs can be successfully and safely met through regular transportation before placing a child in a more restrictive mode of transportation, such as a special school bus, or through a contracted vehicle or a board-owned vehicle. So we always want to look at regular transportation first and then move on to something more restrictive if that is necessary for the child. LRE under Section 504 and the ADA. Section 504 and the ADA are very similar in a lot of respects, and they both state that unless there is a legitimate, non-discriminatory reason for it, basis for it, requiring students with disabilities to ride in a segregated special education bus simply because they have a disability, and for that reason alone, that may violate Section 504 and the ADA in terms of discrimination, which is what the OCR oversees. So saying that, this is a child with a disability, we're automatically going to put them on a, special bus and segregate is something that OCR or the U.S. Department of Justice under the ADA would frown upon. If such a separation is necessary because of a student's disability or to meet that student's needs, then Section 504 and Title II of the ADA would not necessarily prohibit that. That would kind of be an exception where they would say, okay, this isn't discrimination, this isn't necessarily segregation, it's that they're doing what's appropriate for the student. They're not doing it solely to separate and keep students with disabilities apart from their non-disabled peers. There's some guidance that's available. Both are letters from the Office of Special Education Programs. OSEP is the office that sets policy within the U.S. Department of Education. And while the guidance in OSEP letters the first one arose in the context of preschool transportation, students who were enrolled in a Head Start program. This question could very well arise in other educational circumstances, asking whether a non-disabled student could ride on a special bus could arise where a school is attempting to combine transportation for students with disabilities in an effort to implement the IDEA's least restrictive environment requirement. And so that might also implicate the same considerations. But letter to Lucia Harms, and I'm not sure if I'm pronouncing that right, so forgive me in advance. It's from OSEP, Office of Special Education Programs, in 1993. And it does say that there are some limited circumstances where students without disabilities may be allowed to ride in a vehicle funded under IDEA Part B without cost allocation from other funding sources, other district funding sources. And the requirements are, these are the limited situations. The vehicle must make the same trip, has to have the same route, and incur the same expenses whether or not non-disabled children are aboard the bus. The other requirement is that the district may not displace a student with a disability in order to place non-disabled students on the bus. So none of the non-disabled students may displace a student who needs special transportation from their vehicle. If it's full with students who have disabilities, it's full. IDEA Part B funds, special transportation funds, may not be used to purchase or operate a vehicle that is too big for the intended purpose of providing transportation to students with disabilities. So if you're purchasing a smaller size vehicle to provide transportation as a related service for students with disabilities who need that service, if that's your intention and you know that that is the purpose for the purchase, you may not use IDEA Part B funds for that. Simply, to avoid, purchasing another vehicle and allowing non-disabled students to ride on that smaller vehicle and transport them. That's not allowed. So if you know you're buying as a district, you're buying a smaller special bus to transport students with disabilities, and you know that that is the purpose, you cannot use IDEA funds to purchase such a bus. The second letter, and this is used in the context of students who are homeless from OSEP. It is called Letter to Bowman from August of 2013. And it says that generally IDEA Part B funds, as a general rule, must be used only to pay the excess costs of providing special education and related services to students with disabilities. That is the focus of IDEA Part B funds, are to meet the needs of students with disabilities. However, there is a permissive use of fund provision under the IDEA that may apply here. And the federal reg is cited for you. And it says IDEA Part B funds may be used for the costs of special education and related services provided in a regular class or other education related setting, which would be a school bus, to a child with a disability in accordance with the IEP of the child, even if one or more non-disabled children benefit from these services. So if a non-disabled student would benefit, there is some permissive use of funds for that. And continuing on with Letter to Bowman, schools and districts may use IDEA funds when it results in an incidental benefit to non-disabled children as a result of special education and related services provided under the IDEA to children with disabilities. So if there is going to be an incidental benefit, for example, a sibling riding with their sibling who has a disability on a special bus, there's going to be a related incidental benefit to the child without a disability, then that would be a permissive use. There could be situations where, although buses are purchased for the express purpose of transporting students with disabilities, those buses would not be full, and buses should not be purchased with IDEA funds with the expectation that the buses will be used in whole or in part to transport children without disabilities. And that goes to using IDEA funds as stated in the slide before to purchase the vehicle. There may be other expenses if the bus is not full, where there may be a way to use permissive funds if regular students are transported on a special needs bus, if there's an incidental benefit. There's an example included for you. An example of improper spending would be where a district uses IDEA funds to purchase more buses or larger buses that are necessary to provide transportation to students with disabilities who require such transportation for the purpose of using those buses, or extra seating from those buses to provide transportation to student without disabilities. So that would be an improper use if they purchase more special needs buses, or larger buses than are necessary to bring students without disabilities on board, then you couldn't use IDEA funds for that if you have that expectation. Let's see here. Routing and scheduling considerations. Pickup and drop-off points. What the next section is going to talk about are what factors should an ARC team consider for a student who has a disability when determining whether the district or school needs to provide an alternative bus stop location or whether it needs to provide door-to-door service to the student. Different factors to consider as the Admissions and Release Committee meets with transportation staff should be the student's age, the nature of the student's disability, the distance the student will need to travel, the nature of the area. We'll talk about that in a little bit with regard to a case in traffic. Student's ability to get to the bus stop safely and arrive there safely. The student's ability to wait safely, independently at the bus stop for the bus. The necessity for adult supervisions or assistance in getting to and from the bus stop. And the student's needs for adult assistance getting onto and off the bus. A lot of students have difficulty with boarding the bus through the steps. Mobility impairment or cognitive limitations of the student are definitely, these are all factors that if I'm part of the ARC team and we're talking about, okay, can the student go to the regular bus stop and be safe? Do we need to do an alternate pickup and drop off location? Do we need to do curb to curb? Do we need to do door to door? And just a bunch of different things. And, for example, the student's age. A student who has a disability that's, in kindergarten may need an alternative bus stop, whereas when they get older, looking at the unique needs of that child and, their functioning, they may be able to just fine get to that bus stop and be there safely and wait, and may not need to be picked up or dropped off, at an alternate location. An example of providing alternatives and door-to-door service is Kennedy versus the Board of Education, and it's from West Virginia. And one of the reasons why I selected to share this case with you is West Virginia is a neighboring state, and it's also a rural state, very much like a lot of parts of Kentucky. And so this involved two families, and I believe that they were related to each other, and they each had a child with spina bifida and who were non-ambulatory. They did not walk. The student's home was on an unpaved mountain road, and the bus stops was located a half a mile away from the home, and the students were unable to walk independently to the bus stop. Sometimes the parents were able to provide transportation, but some days they were not. They weren't able to consistently provide transportation. As a factor in all of this, there was some debate as to whether the road was public or privately owned. Transportation was not provided to the students during the 1984-85 school year. The parents had made a complaint, and the district said, well, we will provide this, we will provide the transportation, but they never ended up doing that. And the district instead provided home instruction placement services to the student, where the teachers would go into the home to provide instruction instead of bringing the students to the school building. The West Virginia Court of Appeals ordered the district to provide the students with transportation to and from the students' homes. In the end, the district ended up having to purchase a special vehicle just for these two families to reach the students, because the regular school bus could not use the unpaved mountain road. What the court said was that the district's failure to make transportation arrangements to enable the students to attend the school denied the students equal protection of the laws. And so the district did end up having to purchase a vehicle under the order of the court. There are 3 other special transportation cases that, while they are not binding on Kentucky, they may be heavily persuasive to a court. The first one is called Los Angeles Unified School District, and it was a state due process hearing in California in June of 2016. And essentially what it came down to is the rule is a California district did not have to provide a 6-year-old student with other health impairment, ADHD, and a hearing impairment door-to-door transportation solely because that's what his mother wanted and preferred. So it's important to realize that it's not the parent's preference, at least in California, and it probably would be very persuasive here, that, if a parent prefers door-to-door just because that's something they want, does not necessarily mean that that's going to be appropriate special transportation for the student. Because in this case, with this 6-year-old, the administrative law judge ruled that the district had provided the student with appropriate transportation services when they assigned a bus aide to the student to meet the boy and to escort him to the school bus. And they felt that providing that level of adult assistance with the aide escorting and meeting the student and escorting was adequate special transportation. The education department concluded that the okay, I'm going to move on to the next case. I'm sorry. I was starting to read the information from the next case, so I apologize. Missouri Schools for the Severely Disabled. The general rule from that is that although a bus stop at the student's home curb was legal, and this was back in Missouri 2016, the bus stop was technically okay. It complied with the law. The dangerous driving conditions in the area made it an inappropriate place to pick up and drop off the student. The Missouri Education Department found the district's failure to provide door-to-door transportation under these circumstances deprived the student of a free, appropriate public education. So in this case, the Missouri Education Department concluded that the district erred when it denied the mother's request for door-to-door transportation instead of curb-to-curb transportation. The evidence showed that when the student's school bus stop ended at the street curb, and where it was located was at the bottom of a hill, that when loading and unloading the student's wheelchair, numerous cars and other vehicles would back up behind the school bus. So the traffic was getting very, very heavy. And according to the testimony of several highway patrol officers, the stop cars would not be visible to the other vehicles that crested at the top of the hill. And they were going pretty fast too. The other vehicles, would not see, going at they were going about 55 miles an hour. These traffic conditions increase the chances of a car accident and pose a safety hazard to the student and his schoolmates. That was the opinion of the Missouri Education Department. The district contended that, hey, the bus stop complies with the law. It's technically legal and it complies with state and local traffic laws. But the Education Department rejected the district's argument and pointed out, the Missouri Education Department pointed out that safe and legal are not necessarily the same thing. They're not synonymous. Safe and legal are not necessarily the same thing. If the bus stop selected by a district is unsafe for the students, the district may have to select a different pickup and drop off point for the bus, in order to ensure the students and schoolmates' safety. The third case is the Macomb case. It's from Ohio. It's a neighboring state, also within our Court of Appeals jurisdiction, Sixth Circuit, but this was not a case that went up that far. It was a state education complaint. And the Ohio Department of Education, through the state complaint process, found that a district's failure to modify transportation arrangements following a student's change in residence amounted to a special education IDEA violation. It noted the 26-mile bus ride every morning and afternoon impeded the student's learning and instructed the district to revise the student's IEP as soon as possible. This is a case where the student's parents divorced. The student was originally living with the mother, but her residence changed to her father. The father notified the school in writing several times that this was impacting the student's health, her ability to focus at school, because her bus ride essentially was an hour and a half both ways. And this was having an adverse effect upon the child. The parent, the father, tried to reach out to the school district, but they never convened an ARC meeting or an IEP meeting to discuss this, despite the parents' request to do so. And what the Ohio Education Department explained was that a district must review and revise the student's IEP as appropriate to address information about the child provided by the parents. In this case, the Ohio Education Department noted that when the child moved to her father's residence during the 2015 school year, pursuant to a custody agreement, her bus ride increased to 1.5 hours each way. Although the father reported the commute and how long it was and how it was negatively impacting the student's overall health and ability to focus, the district failed to respond to his calls and letters. The evidence also showed that the district never discussed the student's new residence or the potential impact of the move at the most recent IEP meeting. But the district argued that the student was still living with mom then. But the Ohio Education Department countered that with the district should have promptly convened an IEP meeting once the new custody agreement was finalized and the student had moved to the father's residence. As a remedy, the district agreed to hold an IEP meeting within 2 weeks. The district assured the Ohio Education Department that the district transportation director would attend the ARC meeting or IEP meeting in order to discuss the father's concerns and develop ways to shorten the student's commute. So the first one is about parent preference, Los Angeles. The second one, Missouri, talks about safe conditions and especially concerning traffic and, where your bus drop off and pickup point is and, whether even though a stop may be technically legal is, if it's not safe, you got to find somewhere else. And then the third one was about convening an ARC meeting or an IEP meeting as soon as possible. When you know that there's a change in conditions, in this case, a change of residence that's adversely affecting the student, you've been notified, the district or school has been notified by the parent, and to at least discuss the concerns and to review and revise the IEP as appropriate. Here are some factors that are important to consider when you're in an ARC meeting for considering the length of a student's transit time or the amount of distance for a student with a disability. For some students with disabilities, they have conditions for which a lengthy travel time can really negatively impact a student's performance in terms of their energy level, their ability to concentrate, and in many other ways. So it's important to be aware that, this is a child who may have such a condition and discuss the unique needs of that student in terms of whether the travel time would be appropriate for the student. The ARC should consider this when developing a student's IEP, and if there's going to be a different amount of time than what they would be on the regular bus, then the ARC should designate the amount of travel time that the student can tolerate for special transportation. That should be designated on the IEP. The ARC should consider the age and it's stated before the disability or condition of the student when determining, hey, will the travel time have a harmful effect on the student? If the student's riding for 45 minutes, does that impact them in the classroom? Is that going to impact their ability to learn? Does it impact their health? And then the final bullet, travel time cannot be counted as instructional time and cannot be used to reduce the length of the school day. So when you're looking at dismissal times and you're looking at, possibly boarding students with disabilities early, or you're allowing the student who rides special transportation for the bus to arrive there late and they're missing instructional time, that could be very problematic and could potentially arise in a denial of FAPE or where a parent might file a formal complaint or might request a due process hearing. The next slide talks about a student's right to have special transportation for equal access to participate in extracurricular or non-academic activities. There's some commentary there from 2006 as well as the regulation. An extracurricular activity should be included as part of the student special education program by the IEP team or the ARC. If it becomes part of the student's required program and the student's participating, then the district must provide transportation as a related service. Likewise, Section 504 also requires district to provide transportation services that allow the student with a disability an equal opportunity to participate in extracurricular activities. And that would include, after school clubs, after school activities such as, band practice, summer band camp, just, chess club, if they're having meetings outside of the school day or if they're traveling for a competition, special transportation would need to be provided to allow the student to have the equal opportunity to be involved. Here's some pointers for field trips and extracurricular activities when the ARC meets, and transportation staff should be included in these meetings where you're discussing transportation. The team should talk about any field trips and extracurricular activities in which the student may be participating during the school year. The team should talk about and determine what special transportation services the student with the disability will need to participate. And that may mean different things for different students depending upon their disability. So what would transportation mean for that individual student to participate in that activity or trip? Document and describe in the IEP or the student's 504 plan any special transportation services to be provided that will allow the student to participate in field trips and extracurricular activities. So not only do you have to decide what are we going to do, but you should also outline, these are the steps we're going to take when there's a field trip. These are the steps we're going to take when there's an activity to make sure the transportation arrangements are made for the student. Be cautious with the wording that you place in a student's 504 plan. Be sure to document any transportation accommodations a student may need in the 504 plan, but be careful to use wording that does not guarantee or promise the student's participation if the student has to meet eligibility requirements or criteria to participate. For example, a cheerleader who has to go to tryouts, special transportation if they're not being held and transportation is required. Yes, that student should be allowed the opportunity to try out, but that doesn't automatically mean that, if the student doesn't make the team, that doesn't automatically guarantee that the student's going to be placed on the team solely because they have a disability. Now, if they make the team and they just need some accommodations, that needs to be specified in the 504. But there is a difference there between, meeting eligibility criteria and allowing the child to try out versus, okay, once they're part of this activity, what do we need to do in terms of accommodating? So be careful with your wording there. School and district administration should diligently and carefully communicate special transportation arrangements made by the ARC with relevant staff members. And these include, by relevant staff members, I'll just give you a few examples. This could be coaches, teachers, club sponsors, those who are essential and assisting in these trips and activities. There are a few more slides on safely transporting with oxygen. The two big challenges that face districts are training drivers to deal with the specific needs of the student in transit and training drivers to handle and transport oxygen canisters properly and safely. Kentucky has a guidance document, Kentucky Minimum Specifications for School Buses 2022, and on page 88 of that document, there is information about Kentucky's rules for safely transporting oxygen. So it's important for you to possibly pull up that document at the link and particularly focus on page 88 for safely transporting students who are oxygen dependent. Here is just some general tips, general guidance from the United States Department of Transportation for transporting oxygen on the bus for students who require oxygen. Only transport oxygen when it is medically necessary for the student. Transport oxygen cylinders in compliance with the manufacturer's directions. Usually the instructions are printed on a label that is attached to the cylinder. Closely look at each cylinder and inspect it before loading it onto the school bus. Be sure that it does not have cracks, leaks, pits, or dents. An oxygen cylinder or canister that is dented or that contain pits should not be moved. So that there needs to be a plan for what are we going to do if we see one that's dented or contain pits? How would that be safely removed? Limit and don't move it from one place to the other. Limit the number of cylinders transported, oxygen cylinders transported as much as you can. Excuse me. Carry the cylinder with both hands. If you drop the cylinder canister, the impact might damage the valve on the canister, and avoid rolling or dragging the canister. So you need to carry it using both hands. Secure each canister in an upright position. And in the next slide, I think we'll talk about securing the canister, but it should be upright. And ensure that each canister is kept away from heat sources or any possible sparks, because oxygen is flammable, as as we know, and could quickly accelerate a fire in a most dangerous circumstance for staff and students. About securing and storing it, oxygen, the canister. Secure the canister so that it doesn't interfere with the operation of the bus. Secure the cylinder so that it does not get thrown or become a projectile. Secure the canister so that the cylinder does not protrude or stick out into the bus aisle. Don't cover the canister or the cylinder. Protect the neck and valve area of the oxygen equipment to prevent release of oxygen when it's not in use. And if a student is on a ventilator, secure the ventilator close to the student, and in wet conditions, be careful with lubrication of parts of the cylinder or the ventilator. As far as care and maintenance, avoid using oily rags to clean equipment, especially because they might have flammable material on them. So we don't want anything that could be flammable to touch the oxygen container. Do not lubricate valves, connections, or regulators with oil. Keep the canister cylinder in a well-ventilated location. Make sure that that there's some good airflow where it is. Make certain there are no kinks in the oxygen tubing. Otherwise, that The student may not be able to have access to the oxygen that they need because it might be blocked. Ensure the connections to the canister and the cylinder are secure. And please never turn off alarms that are connected with the equipment for the student's safety. Two other things that I'd like to stress are, be sure that you have a backup plan in case, like the school bus monitor or the school nurse or whoever's providing assistance on the bus, adult directed assistance, have a backup plan to make sure that the IEP is still fully implemented and that special transportation as defined for the child is provided. And please practice and rehearse a well-designed plan for evacuating the school bus safely when a student has oxygen. It can be the difference. Practice can be the difference between, life and death. So it's important that you all have a well thought out plan for how to safely evacuate the student and the oxygen, and practice what you would do in the case you would have to evacuate the bus. Service animals. Service animals are covered mostly under the ADA. On page 41 of the Special Transportation Guidance document, there is a section about service animals. Service animals are not specifically addressed under the IDA or Section 504. There are just a few things to recall that right now, as defined under law, a service animal has to be a dog or a miniature horse. A dog or a miniature horse, to be a service animal, has to be trained to do a specific task. That is a requirement. They must be trained to do something. And the ADA does not cover comfort or support animals in terms of being a service animal. District and school staff, they may not ask for documentation of the training or proof of certification for the animal. That is something that, that the student would not be required to provide under the IDEA or the parent. And it is permissible for school or district staff to ask about the specific task that the animal performs and proof of vaccination that would be required for the animal under state or local law. So, a dog requires certain vaccinations under Kentucky law. The school or district can certainly ask for proof of vaccination to make, to ensure that, it is a safe animal. They can also ask, what does this dog do? Well, this dog can tell when this child is having a seizure and alert the student, or, this one will help, get certain items off the shelf or whatever it might be. But those are specific tasks. Bus suspensions. I'm going to get a little bit into discipline here. The thing that I really want you to know is that when a student has special transportation, as written in their IEP, if the student gets suspended from the bus and the district does not offer an alternative form of transportation, then that could be considered a full day of suspension from school for IDA disciplinary purposes. Even if the parent decides we're going to transport the child and bring them to school, certainly that can be arranged in advance, and arrangements can be made to reimburse the parent from mileage if the parents choose to transport the child and provide the special transportation that way and it's agreeable. But even if, the child gets suspended for the bus and the parent brings them, they've missed a related service. So it's important to note that that would be considered a full day of suspension for the purposes of the IDEA's procedural and disciplinary safeguards. Restraint and seclusion. In Kentucky, we do have a restraint and seclusion regulation, 704 KAR 7:160. And I would just be very, very cautious. Please know that the OCR does not consider adaptive devices or mechanical supports which are used to achieve, proper body position, such as, something that's going to, keep the student sitting up, or core strength up, balance, or alignment. Those would not be considered aversive restraint. Vehicle safety restraint, such as a seat belt or a harness for the transport of a student in a moving vehicle, if the ARC agrees that the student needs those, and use of those is to meet, to address the student's transportation in a safe manner and not as a disciplinary technique, then that would not be considered an aversive restraint. So please distinguish between the two. Restraints used for the physical safety of the student and the needs of the student versus using restraint for behavior management. Let's see here. There's also a Dear Colleague letter from OCR in 2016 called Dear Colleague Letter, Restraint and Seclusion of Students with Disabilities. You might want to refer to that letter for further information. And then repeated use of a physical restraint should be a red flag to indicate that the school or district administration need to come together to discuss concerns with the student's behavior and revisit the student's behavior intervention plan. There may need to be some revision or some changes. Kentucky regulation requires ongoing documentation of each and every instance of physical restraint or seclusion, including those that occur on the bus for disciplinary purposes or for safety reasons. Information on Medicaid. This is going to be a really quick slide. Below is a link to the School-Based Health Services Technical Assistance Guide, and it does contain some information on reimbursing for special transportation services, reimbursing through Medicaid when special transportation services may be medically necessary. And so the rules for that would be found in the Technical Assistance Guide. And with that, I'm going to move on to Jen Riley and allow her to talk about transporting students who are in preschool who have disabilities. Thank you, Jen.
Thank you, Susan. So, hello everyone. My name is Jen Riley. I am the Part B 619 coordinator for the state of Kentucky. I also work within the Office of Special Education and Early Learning as a consultant as well. Today, I'm briefly going to discuss special considerations for preschool transportation. Susan, if you don't mind to, I will just say forward, please, if you don't care to progress us through the slides. So we're ready for our next slide.
Will do.
Thank you. So special transportation surrounding state-funded preschool services are targeted to children that meet the eligibility requirement for preschool services for state-funded preschool. And you do that in two ways. You do that by income and you do that by disability. 702 KR 5150 It establishes transportation requirements for preschool children. It discusses driver assistant training and certification, liability insurance for driver's assistants, and safe supervision to and from the bus stop. Forward, please. Typically, most children in state-funded preschool that have IEPs, they ride a regular school bus without the need for special accommodations or related services. Driver assistant training and certification training should relate to the transportation of special needs students. Disabilities that require wheelchairs or other mobility adaptations might require the use of a special bus. And the most common adaptation would be the use of a child restraint system or a harness. Forward, please. Concerning child restraint systems, or CRS, training on proper restraint and proper use of restraint is imperative to prevent injury, death, or lawsuits. So you want to make sure that everybody on that bus is properly trained in the use of child restraint systems. Forward, please. Surrounding child restraint systems, use of CRS may be appropriate if it's necessary to ensure safety of the student, other students, and/or safe operation of the bus. Use of CRS is an art decision. You have to have parental input and involvement, and it's determined individually based on the child's distinctive needs. If the use of CRS is needed but is not specified in the student's IEP, or if the child does not have a disability, the preschool coordinator and special education director need to be consulted. Some districts use a parent waiver form when CRS is needed but not included in the IEP, or when the child does not have an IEP. Forward, please. Using CRS in a state-funded preschool program. So when would the use of a seatbelt or a harness be appropriate? The use of a seatbelt or a harness for a student may be appropriate when it's necessary to ensure the safety of the student, other students, and/or safe operation of the bus.
I'm sorry.
You're fine. You're fine. So the next slide, Susan, goes back to you. And just before we hand it off to Susan, I do want to touch base that for all preschool students, just a reminder, there needs to be a monitor on the bus for all preschool students, not just students with disabilities. And also, all students need to be handed over to a parent or guardian whenever exiting and entering the bus. So make sure that you are having some hand-to-hand contact when you're handing them over to someone at home, or they are being delivered to you to board the bus, and make sure that all preschool students have a monitor on the bus to assist. From there, I'm going to hand it back over to you, Susan, about how you can get support.
Thank you so much, Jen.
You're very welcome.
So if you're running into concerns or questions, or you feel that you need some assistance with a transportation situation for a student with a disability or early childhood, there are steps to take. Bus drivers and bus driver assistants or monitors should first try to share their concerns with the school administration, the district's preschool coordinator, and/or the district's transportation director for additional guidance. Sometimes things can be resolved at that level and questions can be answered. When a transportation or safety issue involves a student with an IEP or 504 plan, the district's transportation director should consult with the district's special education director about the issue. And a big question that should be a point of discussion is, would an ARC meeting be needed, or would it be appropriate to get all of our heads together and talk about what's going on during special transportation, or what's going on the bus or the vehicle? If staff is still unsure how to proceed, please feel free to contact the local educational cooperative, which we're going to talk about in an upcoming page, or contact one of the consultants within the Office of Special Education and Early Learning at the Kentucky Department of Education. And the phone number is 502-564-4970. And we would be happy to do whatever we can to assist you and to provide you with support. I mentioned in the previous slide about the educational cooperatives. Kentucky is fortunate in that it has around a dozen or so regional education cooperatives that provide assistance and expertise for the benefit of member school districts within their area, within their geographical region. And a co-op might serve, maybe 10 or 12 different school districts, but they are there to be a resource to you. The cooperatives provide comprehensive educational services and programs to support their member districts and have schools in their school improvement efforts. And it's really important, that they're there as a resource. The amount of help or assistance they're able to provide, I can't speak to, but it is just a resource for you that can be very valuable in talking you through what the concerns are, providing some technical assistance as well. They do have consultants that are well versed in a variety of areas, such as assistive technology and behavior, that may be able to talk with you. In addition, there are some more resources. Some are written materials, and then there is the National Association of Pupil Transportation's Committee on Special Needs Transportation, and they can also be a valuable resource for you. Our contact information is on this slide number 40, and feel free to call, me or Jen or any of the other consultants. If we can be of assistance, we'll certainly do whatever we can to help. Finally, thank you for being with us today and for learning more about special transportation, and especially a huge thank you for what you all do every day to keep our students safe while going to and from school and in school. Have a great day, and thank you very much.
Thank you, everyone.